Under the McNaughton test for insanity, a person is presumed sane unless, at the time of committing the act, that person didn't know the nature and consequences of the act or the difference between right and wrong. But what if a person knew the nature and consequences of the act and right from wrong, yet acted under the compulsion of an irresistible impulse? The U.S. Court of Appeals for the Sixth Circuit considered this question in Pollard v. United States. Marmion Pollard was a Detroit police officer who was happily married with 4 children. In April of 1956, Pollard's wife and daughter were tragically murdered in their home by a drunken neighbor while Pollard was on duty. Following the murders, Pollard became withdrawn, depressed, fatigued, and emotional. About 2 years later, Pollard got remarried, but on the day before the wedding and in the weeks afterward, he attempted to rob numerous banks and a grocery store. Eventually, Pollard was arrested and charged in federal district court with numerous counts of attempted robbery. At his arraignment, Pollard initially pleaded guilty, but upon a motion from his attorney, the court set aside Pollard's guilty plea and entered a plea of not guilty. During a bench trial, Pollard's attorney asserted an insanity defense, arguing that at the time of the attempted robberies, Pollard suffered from a defect of mind and acted under the compulsion of an irresistible impulse. 6 psychiatrists who examined Pollard also testified that Pollard acted under the compulsion of an irresistible impulse when attempting to commit the robberies. At the conclusion of the testimony, the court ordered a medical examination. In his report, the chief medical officer at the Medical Center for Federal Prisoners agreed with the psychiatrists that Pollard acted under the compulsion of an irresistible impulse when he committed the crimes. Subsequently, the court disregarded the expert evidence and concluded that Pollard didn't act under an irresistible impulse and found him guilty. Pollard appealed to the Sixth Circuit.